In other news now, it is still not very clear whether the two Kenyan accused at the International Criminal Court have reason to celebrate or not. The Assembly of State Parties adopted a report reaffirming that Rule 68 on recanted testimony should not apply retroactively, but experts are advising caution in the interpretation of this decision made last night at the close of the Hague summit.
The standoff at the Assembly of State Parties went well into the dying moments of the meeting, and in the end, Kenya managed to push into the final document the language it wanted, affirming that previously recanted evidence should not be used in ongoing cases at the ICC, and the delegation quickly claimed victory.
Tunataka koti na Bensouda itupilie sasa mbali hiyo kesi. We believe that we will only rest when the two Kenyans, namely William Ruto and Joshua Arap Sang, will be brought from this place and be returned back home. Recanted evidence cannot be admitted on the basis of this rule.
In spite of the optimism by the government delegation, some lawyers insist there is not a done deal yet. Kenyan advocate Gitobi Manyara tweeted, "Despite the bravado by the Jubilee team at The Hague, the applicability of Rule 68 remains in the purview of ICC Appeals Chamber. That is because a case is currently pending before the Appeals Chamber challenging the application of the now controversial Rule 68, and the judges may well rule whichever way they choose." Indeed, the Assembly in its statement affirmed the independence of the courts in interpreting the rules of the Rome Statute. In a statement, Amnesty International accused Kenya of attempting to blackmail the Assembly of State Parties to accede to its demands. The statement issued this evening says in part, "It is deplorable that this effort was undertaken to protect a single individual, Kenya's current Deputy President. The attempt by Kenya to interfere with cases before the ICC is shocking." But Nairobi lawyer Dunstan Omari insists that the judges have no choice but to follow the resolution reached in The Hague.
There is no case. If the recanted evidence is removed, a mere fact that they went to look for recanted evidence clearly tells you that they are presented before the court is not sufficient.
Kenya described her 8-day diplomatic maneuvers at the ASP as a painstaking negotiation process. Foreign Affairs Cabinet Secretary Amina Mohamed saying there was a lot of mistrust amongst state parties, which makes it difficult to pursue a common agenda.
Now we believe the negotiations at this assembly have been candid. And after an unnecessarily protracted process, we have been able to clarify what our common intention was at the 12th Assembly of State Parties. I can assure you, Mr. President, that we shall be alive and we shall be alert to everything that will happen in respect to this resolution. Indeed, it will be a test of whether we are engaged in a meaningful discourse and process or not.
The Kenyan government delegation will now have to await the decision of the Appeals Chamber to know whether the efforts have truly borne the fruits. Some of the KTN News.